Welcome, everybody, to the NCMA COVID-19 Prepare Your Changes and Claims with Confidence webinar. I'm Becky Pearson. I'm a partner in the Government Contracts Group at Venable, and it's my pleasure to be the moderator here and to introduce your speakers. You know, COVID-19 is the biggest force majeure event probably in the lifetimes of everybody here. It really presented, just in the terms of global scope and the shutdowns, a very significant challenge for government contracts and government contractors in particular, and government agencies as well, because the shutdown orders impacted contracts across a broad spectrum in ways people had not foreseen and certainly have not protected in their contracts. In reaction to this, Congress, federal, state, and local agencies have responded with some exceptions to the contract language, which is really not all that helpful. And our presenters are going to help you work through this because it presents that dichotomy between what the contract says and what the relief that might be available is pretty significant. We're going to start off with Barry Hurwitz, who's a partner in WilmerHale's Regulatory and Government Affairs and Transactional Department and a member of the WilmerHale Defense, National Security, and Government Contracts and Cybersecurity, Privacy, and Communications Group. Jessica Aldrich, also from WilmerHale, helped put on this presentation and prepare a lot of materials, and we want to give a great thanks to her. And Barry Hurwitz is going to be describing the CARES Act Section 3610, its implementation, and what comes next. Before we get to Barry, I'd like to introduce the rest of the presenters as well. Next up will be David Edelstein. He's going to be presenting on delay and disruption in the wake of COVID-19. David is a partner in the Asmar Shore McKenna Construction and Government Contracts Practice Groups. He's represented government contractors in a variety of industries, including healthcare, facility services, architecture, military training, and environmental testing. And with him, and also helping put this presentation together, is Allison G. Wax. She's a very experienced in construction issues and claims and disputes, and we're so lucky that she's also been a significant leader in the NCMA DC chapter, and we want to thank her for her work there. Last but certainly not least is Emily Unesh. She's my colleague in Venable's Government Contracts Practice Group. Her topic is going to be force majeure and excusable delay. Emily regularly advises clients on how to strategically avoid disputes and compliance issues before they threaten to undermine business objectives. Among other experience, she has litigated complex claims under a multi-billion-dollar nuclear construction contract, and she's really one of our go-to people on construction issues in Venable. So with those introductions, I'm going to turn this over to Barry Hurwitz to present on the CARES Act Section 3610, its implementation, and what comes next. Barry?
Thank you, Becky, and good morning. I will describe in my segment Section 3610 of the CARES Act, a contractor relief mechanism created specifically to retain contractor and subcontractor workforces during the current pandemic. I will briefly describe this federal contracting authority, how it's being implemented, the connection to existing contractual relief authorities, and comment on potential near-term developments. The CARES Act is a sweeping pandemic relief assistance law enacted on March 27th in response to the COVID-19 national emergency. Section 3610 of the CARES Act provides federal service contractors a legal framework for seeking reimbursement for maintaining compensation to employees and subcontractor personnel who are on paid leave and unable to perform their regular duties due to facility access restrictions imposed during the pandemic emergency. Section 3610 is one measure that supports contractors and subcontractors that need to maintain a highly skilled, mission-ready workforce despite nationwide closures of work sites, mandatory force reductions to implement social distancing policies, and state and local restrictions, where these impacts cannot be mitigated through telework or other remote work alternatives. Section 3610 provides an authorization for contractor relief, but requires agency implementation, which has been furnished in the form of interpretive guidance over the past several weeks. When the CARES Act was initially enacted, it was a bit unclear how agencies would implement it. Now, 2 months later, we have further insight, principally through guidance issued by at least 7 defense and civilian agencies. The full text of Section 3610 is provided here for your reference. Section 3610 allows agencies to reimburse contractors for paid leave at the minimum applicable contract billing rates for a 40-hour work week, where a contractor provides that compensation to keep its employees or subcontractor personnel on payroll and ready to work during the public health emergency that was declared on January 31st. This authorization is temporary and will end on September 30th. The text of 3610 is a bit dense and raises a number of issues that must be navigated in contracting agencies' implementation of this special statutory authority. Breaking down the text of Section 3610, we can draw out the principal elements of the special temporary authorization for contractor relief. First, its applicability. Section 3610 applies despite any other laws that might impact contract administration. Accordingly, the Department of Defense has interpreted this to mean that contracting officers may use any available funds for a contract to pay for contractor relief under Section 3610, and are not limited to funding that is furnished through specific CARES Act or other pandemic-related appropriations. Next, it's a permissive discretionary authorization. Section 3610 does not compel contracting officers to grant any relief to contractors and does not require contracting officers to cooperate in contractors' efforts to maintain their workforces or their subcontractors' workforces, despite pandemic-related facility closures and workplace access restrictions. My fellow panelists will describe other contractual mechanisms that may provide a more compulsory approach. The amounts of available relief are limited. This limitation generated some confusion because it restricts compensation to the rates for an average of a 40-hour work week. But Section 3610 does not expressly provide for the application of the law to firm fixed-price contracts where there are no specified billing rates. As I'll note later, agencies have addressed this and have provided that firm fixed-price contracts can benefit from the Section 3610 authority. Next, relief under Section 3610 is designed to keep employees and subcontractors in a ready state. Without Section 3610, work sites that were closed or shifted to rotating or so-called blue-gold work schedules could lead some contracting officers to believe that they lack or think they lack an authorization to pay for the portion of the workforce that was not on site, but nonetheless kept on call to return to work when instructed. Section 3610 authorizes contracting officers to pay contract rates for those idled workers so that the workforce can be kept intact. Next, the covered time period is limited, ending on September 30th at the end of the federal fiscal year 2020. Further, the law specifies which work sites are eligible for this relief. It applies to workers without normal access to sites that have been approved by the federal government, which includes, according to the statute, federally owned or leased facilities. The subsequent guidance has clarified that this can also include contractor-owned and contractor-leased facilities, not just government sites. The law is also limited to a specific circumstance. Relief is available only for workers who are unable to work at their normal sites and where that work cannot be performed remotely or through telework or other remote mechanisms. And then finally, the law bars duplicative relief. This has been one of the more complex areas of implementation. Many contractors have struggled to reconcile multiple sources of pandemic relief programs, and this provision barring duplicative relief may give rise to questions during audits and investigations. Although implementation of Section 3610 is not uniform across all agencies, here is a brief summary of the key points that can be drawn from the law. The superseding clause, the discretionary authority, the applicability to prime contractors and subcontractors, the applicable rate and length of the work week, the applicability to personnel needed in a ready state, the facility access trigger, the condition that telework won't work, and the prohibition on double dipping. So how is Section 3610 being implemented? The law is subject to a growing body of interpretive guidance that is critical for understanding how a contracting officer might or might not support a contractor's request for relief. The initial OMB guidance issued on March 20th predated the CARES Act, but pointed to FAR clauses that might be implicated by pandemic-related facility closures and force reductions, such as the changes, delay of work, and stop work clauses that my fellow panelists will describe. On April 17th, OMB issued supplemental guidance specific to Section 3610, reiterating that the discretionary authority allows for contracting officers to first determine whether keeping a workforce in a ready state is even in the government's best interest. Agencies are left with freedom to determine the appropriate relief on a contract-specific basis. DoD's Defense Pricing and Contracting has been the most prolific so far in developing Section 3610 guidance. In April, DoD issued a DFARS implementation, providing for contractors seeking relief to document cost impacts imposed by the pandemic, the actions taken to continue work under the contract, the circumstances that necessitated employees to be put on paid leave, why telework or remote work is not feasible, and how the employee leave serves to keep employees in a ready state. Contractors must also ensure that their claimed costs are segregated and auditable. More recently, DoD issued draft implementation guidance that was open for comment through May 22nd. This included a checklist for submission of Section 3610 reimbursement requests that should be helpful for contractors in assembling the information that will be used to evaluate a request for coverage of pandemic-related paid leave for employees or subcontractor personnel. The process steps include, first, the contractor's submittal of documentation demonstrating its status as an affected contractor and the requested amount for reimbursement for paid leave. The contracting officer then determines whether the contractor is an affected contractor, and if so, the appropriate amount of relief. On the civilian side, GSA issued a FAR class deviation on April 21st, setting out a Section 3610 process for FAR contracts, as well as task orders under indefinite delivery vehicles. Under that guidance, delivery schedules and progress payments may be adjusted by amendment to any FAR-based contract without consideration. A contractor may submit a request for reimbursement immediately after paying the idled employees or after paying a subcontractor that has already paid its employees. Contracting officers will reduce any relief by amounts received under other programs. Contractors bear the burden of notifying their contracting officer of duplicative relief to either reduce prospective payments or to provide credits against amounts already received. Consistent with the General FAR Audit Clause, affected contractors are required to maintain records relevant to their requests in an auditable format for 3 years after final payment. There are a few common themes that can be gleaned from this agency implementation guidance. Profit and fee are not included in reimbursable amounts, as that would impact indirect cost rates. Costs claimed under Section 3610 must be recorded separately to facilitate evaluation and auditing. Relief will be reduced by the amounts recovered from other sources. And the agencies that apply Section 3610 have provided that it can be applied to fixed price contracts. The guidance contemplates a negotiated equitable adjustment to cover a separate contract line item for COVID-19 paid leave, even if the contract did not originally contain any reimbursable line items. Agencies will probably retain the existing contract type, so a fixed price contract will likely not end up with a cost reimbursement line item, but rather a fixed price line item reflecting the agreed upon cost for paid leave. Covered work locations can include contractor-owned or contractor-leased sites approved by the federal government for contract performance. GSA's guidance actually presumes that all contractor and subcontractor work sites are approved unless specifically disapproved by the contracting officer. There are some notable differences among the various agency implementations. The wording among the different guidance is not the same, and there is one major difference between DoD's and GSA and OMB's interpretation. Specifically, DoD provides for reimbursement through Section 3610 starting on January 31, the date that the national emergency was declared. GSA and OMB guidance provides for reimbursement beginning on March 27th, the date that the CARES Act was enacted. Section 3610 does not operate in a vacuum. It must be considered within the context of the existing contractual mechanisms that are available for contractor relief. Since OMB and GSA guidance express a preference for avoiding suspension of work and stop work orders if possible, this steers us to the standard changes clause. I'll touch on these just briefly since my fellow panelists will describe this further. The changes clauses can be implicated when a contracting officer imposes work site restrictions or closures that affect the contractor's ability to perform on schedule, entitling the contractor to an equitable adjustment. Under Section 3610, this adjustment can include compensation for idled personnel. The government delay of work clause may be implicated when a government action to close or restrict facility access or to require telework causes a performance delay, or when government inaction, such as delays in approving remote or telework arrangements, causes a delay. If a contracting officer exercises its stop work authority, Section 3610 could allow for workforce compensation to be included in a contractor's equitable adjustment. It's notable that some recent case law casts some doubt on contractor claims for pandemic-related costs. In the recent case, Pernix Circa Joint Venture versus Department of State, the Civilian Board of Contract Appeals upheld the government's refusal to pay contractor costs associated with the Ebola outbreak in Africa. In that case, the contractor requested government guidance on how to address contract performance during the outbreak, and the government declined to provide instructions. The contractor suspended operations and sought an equitable adjustment upon returning to work. The CBCA found that the outbreak did not constitute a cardinal change, a constructive change, or constructive suspension of work, and that the events were an excusable delay, entitling the contractor to a schedule extension, but not additional costs. This suggests that contractors should communicate regularly with their contracting officers about how to respond to the pandemic and the impact on their workforces. Section 3610 implementation remains a work in progress. We can expect new issues and questions to arise in audits, investigations, and enforcement actions. The enforcement tools for Section 3610 are likely to be the same mechanisms that already apply to the relevant contracts. However, contractors that have received other CARES Act relief may face additional scrutiny through the multiple sources of CARES Act oversight. These include the Special Inspector General for Pandemic Recovery, with broad powers to audit and investigate CARES Act implementation. The President's nominee for that position was confirmed on June 2nd. Separate congressional oversight authorities, the Department of Justice, and the Small Business Administration are also enforcing parts of the CARES Act, although issues relating to Section 3610 are quite likely to implicate the regular contract oversight and enforcement mechanisms. For matters involving claims for pandemic-related workforce costs, risks can be mitigated, for example, by documenting any impacts or anticipated impacts on contractor labor utilization. Where applicable, contractors should ensure that the government makes or at least endorses facility closures or restrictions for government sites, and the government endorses any decisions relating to telework or other remote work. Contractors should communicate regularly with their contracting officers. This is particularly important because relief under Section 3610 is discretionary, and that means that a contracting officer must be persuaded that it is necessary to maintain the workforce in a ready state. Contractors should separately track employee and subcontractor standby hours induced by facility restrictions or social distancing requirements. They can mitigate impact by reassigning employees to other work before putting them on leave. In general, it's wise to seek relief early rather than holding claims for a consolidated adjustment. And of course, contractors should continue to perform to the maximum extent possible. Returning to work, while welcome, introduces a set of new questions to address. On April 20th, OMB issued guidance for agencies to resume operations, focusing on a phased regional approach toward restoring normal operations. Agency heads are encouraged to revisit telework policies and agreements in order to move toward normal operations. Contractors with Section 3610 workforce issues will face questions such as whether their locations will be repopulated by facility or by contract, the availability of transportation to those work locations, the availability of personal protective equipment and whether it will be an allowable cost, the availability of schools and child care to facilitate workforce return to work. These issues may persist well past September 30th, raising the prospect of continued workforce disruptions beyond the current sunset of Section 3610. Possible supplemental legislation in Congress may affect these workforce relief mechanisms. Specific provisions that are being discussed include setting January 31st as a uniform start date. As I noted, March 27th is the date provided in GSA and OMB guidance. Continuing to maximize telework or creating a risk that some work may remain unsuited for remote or telework options is another area that might be addressed in upcoming legislation, as are potentially paying prime contractors faster within 15 days of submission rather than 30, or providing leniency in performance ratings for pandemic-related contract disruptions. In sum, as of today, Section 3610 provides an authority that can encourage contracting officers to help contractors and subcontractors to recover costs for workforces that are left idled and on standby due to pandemic-related facility issues. But agency implementations are not completely consistent, and contracting officers have great discretion in providing that relief. Now, Becky, I'm happy to take a couple of questions now, or we can turn the program over to David and Allison to continue our discussion.
I think the plan had been that we'll save questions for the end, but certainly if any of the people who are attending have questions, there's a box to enter those questions. We'll take your questions then, and for now we'll turn it over to David Edelstein and Allison G. Wax to describe delay and disruption in the wake of COVID-19. Thank you so much, Barry.
Thank you.
Great. Thank you. This is David Edelstein from Asmar, Shore, and McKenna. I'll be talking a little bit this morning about delay and disruption. There's a few parts of the presentation that Allison and I will be giving today, answering these 4 questions that you see now. What is the difference between delay and disruption in the COVID-19 context? How to determine what really caused the disruption? How to allocate who's responsible for the costs that result from disruptions, including changes in law, and then who bears the risk of increased costs due to other disruptions, such as supply chain disruption. The first question here is what is the difference between a delay and disruption, especially in this COVID-19 context? These are 2 words that tend to travel together a lot, and as the Court of Federal Claims has recognized, these 2 claim types often arise together in the same project. But they are different claims, and in the COVID-19 context, they're going to be treated differently in terms of recovery of costs. So what is a delay cost? Delay cost and delay claim is that the project has been extended for a longer period of time because of some event outside of the contractor's control. The types of costs you would see in a delay claim are the costs that can be referred to as either extended general conditions or more generally just pure time-related costs. These are things like rental costs for site offices and phone, internet, utilities, equipment rental, even project management time that isn't tied to direct performance of some task by sort of hourly labor. And so these are costs, therefore, where if your monthly cost for these type of things is $10,000 and the project is extended by 2 months, you will incur $20,000 worth of additional delay costs. Disruption, on the other hand, refers to not being able to perform the work as efficiently as you initially planned. And that's going to be a massive issue in the COVID-19 context, both during the pandemic or during the existence of pandemic-related restrictions, and then also afterwards, as we anticipate that there will be a lot of attempts to catch up for missed work via acceleration and other things of that nature. So the type of costs that you'd see as disruption costs are things like overtime costs, like additional labor to perform the same task because of inefficiency factors. During the pandemic, that will be things like having to perform work with only a limited number of people in a certain space, or with additional PPE on, or with limited access to the site. And so those types of inefficiency factors, crew size inefficiency, stacking of of trades, stacking of your own crews, concurrent operations, dilution of supervision. Those will all increase the actual labor cost in performing contracted tasks, and that will be referred to as a disruption cost. So when analyzing these disruption costs, the important question here is going to be who or really what caused it. And there are certain disruption costs and certain delay costs that really are just going to be caused by the pandemic itself. And as Barry just noted in that, referring to that Pernick-Circa case, these are the type of costs that it may be difficult to recover from the government. And that would be something like an illness in your own workforce. Possibly, and Allison will talk about this later, unavailability of supplies or general labor shortage that's just really caused by the fact that this pandemic exists. The more interesting costs from our perspective are those that are caused by the government, by change in law, or whether it's a change in law and regulation that's come down from on high, CDC guidance, things of that nature, or more specifically, if it is restrictions that are imposed by the site, the persons in charge of a particular work site, and we have seen that where memoranda and guidance will come down from the site operations saying, here are the restrictions that you must abide by in order to perform work on this site at this time. And that will be access restrictions in terms of how you get into the site and what that you need to go through a screening facility with temperature checks before you go onto the site. It will also be social distancing kind of restrictions, a number of people per room, or additional PPE requirements, additional sanitation requirements, that will all just serve to interrupt and impact the normal assumptions that the world makes about how work progresses. Those that have a bit of an easier time, and I think it's important to attempt to the greatest extent possible to frame those as kind of changes that were imposed by the government and by your contracting parties. There are going to be edge cases here as well, and I think one of the great examples of that, and this is something that we've seen from a few different sides, is things like quarantine of close contacts of infected workers. That's going to be is that an impact of the pandemic itself, or is that a imposed restriction by the government? I think that's an open question, and the answer to that could be of fairly significant importance. So those are the sort of two major types and of costs that might come out of the COVID-19 pandemic. I think a general overview of when they may or may not be recoverable under your various contracts, and of course the primary advice, which I should have said at the beginning, is check what your own contracts say. A lot of this presentation is on the assumption of fairly standard federal government contracting clauses, but there are modifications that are made in particular contracts. There are subcontracts that flow down government contract clauses more or less effectively or with certain modifications. So we've given a general overview, understanding what the specific force majeure clauses and changes clauses in your contracts say should always be step one. Now I'm going to turn it over to Allison, who's going to talk about some changes in the law with respect to COVID-19 that are of interest here. Allison.
Thank you, David. So as David said, just generally speaking, in order to prove a disruption claim, the damage does have to be caused by something for which the government assumed the risk, or for those of you who are subcontractors on federal projects, for which the prime contractor assumed the risk. And so the question becomes, in what ways can a contractor argue that the government or prime contractor assume the risk of COVID-19? So right now, one of the main ways contractors are looking to push this risk upstream is by looking to contract clauses regarding changes in law. So COVID-19 has resulted in issuance of guidance from state and local authorities, which may or may not be consistent, from CDC, from OSHA, concerning if and how your projects, I would say pretty heavily impacted would be the construction industry, to see how those construction projects can proceed just because of the sheer number of people that have to be in a given place at the same time. So while these orders, so for example, if a job site is not shut down, sites need to have a certain number of available hand washing stations, maximum number of personnel allowed on site, mandatory protective gear for all workers, etc. Now, these changes result in a loss of productivity, but also increased direct actual costs. So, for example, the cost of installation of hand washing stations, the cost of the additional protective gear. So, these are direct costs versus the more subjective or kind of difficult to pin down delay and disruption costs. So normally for COVID-19, we're operating in kind of a no man's land. It was, and I'll talk again about the case that Barry and David both mentioned from CBCA. The timing of it was impeccable, really. But for the most part, we're operating in this kind of new territory. There's not a lot of case law we can look to for guidance. But with regard to changes in law, there is actually some precedent we can look to. And that's from the Federal Circuit, Hills Materials Company. The Federal Circuit in that case was asked to interpret a clause that required the contractor to comply with standards issued by the Secretary of Labor. So the government wanted to hold the contractor responsible for changes to OSHA requirements, which would have resulted in the contractor bearing increased costs as a result of those OSHA requirements. And the contractor requested an equitable adjustment to the contract sum for those increased costs, because the OSHA requirements were enacted after the parties entered into the contract. The contract also contained the standard permits and responsibilities clause, which I have the text here. The relevant part provides that the contractor shall, without additional expense to the government, be responsible for obtaining any necessary licenses and permits and for complying with any federal, state, and municipal laws, codes, and regulations applicable to the performance of the work. And this language is pretty similar to what you can find in private contracts as well. So the government argued that the language of that permits and responsibilities clause placed the risk of changes in law on the contractor. And the contractor argued that the language requiring it to comply with standards issued by the Secretary of Labor qualified the permits and responsibilities clause with respect to OSHA requirements by using the word issued. And so, as opposed to, I guess they expected the contract to be written in the present tense, because honestly the Federal Circuit said that the word issued in the past tense logically refers to regulations already issued, not to changes which may occur in the future. Now, the problem with this rationale, and I guess good on the contractor for making this argument and winning with it, is that really the word issued in this provision is not a verb, but it's an adjective. And so grammatical error aside, we often complain about the, I don't want to say poor, but dubious decisions coming from the Federal Circuit with regard to government contracts. I think for example, year in review, West's year in review on government contracts, it's almost a bit of a running joke. Now, usually these poor decisions benefit the government, but here they benefit the contractor because the Federal Circuit held that the contractor was not responsible for OSHA regulations or changes enacted after the contract was signed. So we won't complain too much about that one. Now, another increase in costs we might see that can result in some requests for equitable adjustment being prepared and submitted will be supply chain disruption, costs associated with that. COVID-19 will result in price increases unrelated to government orders or requirements. So this will be increased material or labor costs, or even unavailable of materials or actual bodies on the site to do the job. So for firm fixed price contracts, the risk of price increase is with the contractor. And in the case of a cost reimbursement type contract as opposed to a firm fixed price, the contractor is entitled to be paid for the cost of the work, but generally subject to a guaranteed maximum price. And I think Emily, I think she might talk a little bit later about some of the private contracts in construction, like the A201 from AIA, and so this applies to those agreements as well, which are used pretty frequently. Price escalation in the context of a guaranteed maximum price or a cost reimbursement contract that is not tied to an actual change in scope, so compensable change to legal requirements or increase in taxes, that doesn't necessarily entitle a contractor to an increase in the GMP or the guaranteed maximum price. So you need to prove that this is a change. And for each contract, there are a few different types of changes clause. Those are found at FAR 52243. For construction, I believe it's 52243-4. So you need to make sure that you know which changes clause applies to your contract. But, for example, if your contract requires you to perform painting work or demolition work, your contractors and your workers are required to wear N95 masks. Well, as you might have heard, there is a worldwide shortage of N95 masks. And so is this a change? Well, it probably will depend on when you entered into your contract. If you entered into your contract last fall, then this shortage is, I would argue, an unforeseeable event outside of your control. If you entered into this contract in March, it's a little bit of a harder argument because it was foreseeable as of March. Now, both Barry and David mentioned Pernick Circa joint venture v. Department of State. This was, again, a very timely case regarding the Ebola outbreak in Africa. And in light of this case, I think a lot of us were expecting leniency from the courts with regard to excusable delay, and that is consistent with this case. But as we're seeing from the CBCA case, compensability might be a different story in terms of what we can expect, courts to be a little bit more forgiving on, at least with regard to government contracts. Now, for some contracts, you might have an economic price adjustment clause, and that's found at 52216-4. I think when I was talking to David about this, he said he's maybe seen one. I think I've seen one, in the past however many years now we've been doing this. So they're not particularly common. If you have an economic price adjustment clause, then you're in a better position than a lot of other contractors. Now, if you're a private contractor or a subcontract to a federal prime contractor, then you might have, assuming your prime contractor didn't flow down all of the clauses for verbatim, you might have a price escalation clause that can cover these costs. So in the absence of a provision on that, though, I would say that the risk of the price increase generally stays with the contractor. So the other way that you kind of have a bit of an out is if supply chain disruptions are so extensive that they result in commercial impracticability or even impossibility of performance or frustration. The contractor may be able to claim for some kind of relief under those theories, or potentially, have some kind of argument that, it's relief from performance. But that is incredibly difficult to prove. I guess you could come up with some extreme circumstances, like if COVID-19 just decimated your workforce and you had no one to perform the work. I could see that being the type of situation in which this would come into play. These types of legal theories are very, very difficult to prove, and you have to prove them up, pretty extensively. So I'm going to pass it now to Emily to talk about force majeure and excusable delay.
Thank you, Allison, and good morning, everyone. Thank you for joining us this morning. My name is Emily Unash, and I'm an associate in the Government Contracts Group at Venable here in Washington, D.C. I'm going to take a little step back here, although I think it's a good segue from what Allison was just talking about with contract avoidance doctrines. So I'm going to take a step back and talk a little bit about what is this concept of force majeure and excusable delay. And as you all may have heard, force majeure is kind of this contractual concept that's sort of getting its 15 minutes of fame, I would say. You see it a lot in the media these days. So what is force majeure? The Webster's Dictionary defines force majeure as a superior or irresistible force, or perhaps more relevant to the contractual context, as an event or effect that cannot be reasonably anticipated or controlled. So when we look at a force majeure provision in a contract, that provision is, again, a contract avoidance provision that provides a contractor or a contracting party with a legal defense limiting their potential liability for events that are unforeseen and outside of the control of the parties. So we'll go into that in a little more depth, but it may seem like a simple definition, but again, as Allison was talking about with the type of legal defense of impossibility or impracticability, this can be a difficult one to prove. And it also doesn't apply the same in all different contexts. So for example, although you may see force majeure provisions in your commercial contracts, it's very unlikely. In fact, I don't think I've ever seen a force majeure provision in a government contract. Government contracts tend to include excusable delay clauses, which I'll get to a little later. So it's important to note, and I think all of the presenters here today have mentioned, that this type of provision is a contractual provision, which means it's going to be governed by the particular terms that are in your contract. So although I'm going to go over some of the kind of basic underlying provisions of a force majeure clause, just note that it may be different in your particular contract, so you'll need to take a look at your contract to determine what actually applies. So first question, what is a force majeure provision? What does it actually include? So some force majeure provisions are not actually going to include the words, epidemic or pandemic, but they'll often refer to some sort of event that is beyond the party's control and the event that may excuse non-performance or allocate risk differently than is otherwise provided in your contract. So it's important to note, again, in addition to just looking at your contract for how this provision is written, if it's included at all, the law of the applicable jurisdiction may also come in to affect the way that your force majeure provision is going to be applied or interpreted by a court. And I think, as we heard from Barry earlier, as well as from David and Allison, different jurisdictions, especially in light of this COVID-19 pandemic, with emergency orders and with the CARES Act, and the fact that there's just not a whole lot of case law on when these type of provisions apply, it's going to be really important to kind of watch this as it unfolds and see how your particular jurisdiction is going to interpret these type of clauses. So when we look at what is in a typical force majeure provision, again, you're going to need to look at the precise terms that are in your contract itself, but there are some general features that are going to be found in most force majeure provisions. The first is that the event that triggers the provision must be outside the reasonable control of the parties, and it cannot have been an event that was foreseeable at the time of creating the contract. Another common theme is that the relevant event must materially affect the ability of the parties to actually perform their obligations. So typically, force majeure provision is not going to become applicable unless performance really becomes impossible. It's not going to apply just because performance has become simply burdensome. And again, the terms of your contract are going to tell you what the trigger is. So the contract may say that your performance has been impeded or hindered. It may actually say that your performance must have been entirely prevented for this type of provision to apply. A disruption, generally, if a disruption that you're talking about has only impacted your contract's profitability, that's also not going to trigger a force majeure event unless there's some sort of actual provision in your contract that would include profitability as one of the triggers. But in general, if your contract just becomes less profitable, or even if you're losing money on it, it doesn't necessarily mean that this provision is going to be triggered. Same with an economic downturn. I know there's been a lot of anxiety right now about the economic downturn and recession that the United States has entered, but generally an economic downturn or just adverse business conditions are going to be insufficient to constitute a force majeure event. And that may be the case even if you can show that the economic downturn was caused by COVID-19. Again, you're really going to have to go back to the language of your contract and see, well, what is the trigger? What do I have to show? Typically, it's not just going to be that there's unfavorable economic conditions. So another requirement for force majeure to apply generally is that the party who is claiming the defense is going to be required to notify their counterparty of the relevant event and also to provide the required evidence to show that to show the nexus or the causation between the force majeure event, so in this case maybe COVID-19, and the impacts to the contract. So different contracts are going to have different notice provisions. Some contracts may have really detailed, procedures and timelines for your notice provisions. Some may just state that, you need to provide notice as soon as possible or as soon as practicable. It's also important to note that the jurisdiction that you're in, so if your contract dispute ends up going to a court, the jurisdiction where you're in may interpret notice provisions in a strict sense, or they may be more lenient. So it's going to depend, again, on not only on the wording of your contract, but who is doing the interpretation of your contract. If your contract has a force majeure provision, but it's actually silent on, when or how you should provide notice, it would still be advisable for the party claiming the force majeure event to provide a preliminary notice really as soon as possible, as soon as they become aware of the event, so that they can begin building their evidence and building their record. And that notice, again, it can be amended, it can be supplemented. It's generally better to provide notice early, and you can always supplement rather than to wait and try to provide, one consolidated claim at the end. So another really important requirement for claiming a force majeure contract avoidance clause is that you are required to mitigate your damages. And this is really the case with any sort of contractual damage dispute, but as with any other contract avoidance doctrine, you have to show that you have taken steps to try to avoid the harm that's being caused by the force majeure event. So those steps may be increasing the amount of overtime that you're doing, putting in place, other mechanisms for ensuring that your workers are able to perform. It's important as well that you look at mitigating the impacts of the force majeure event downstream. So, looking at your subcontractors and, thinking about how are you going to mitigate the damages so that you're better able to prove your force majeure claim. And again, force majeure, it's important to note, force majeure provisions rarely include an economic recovery angle. So they're often the remedy that you can receive from invoking a force majeure clause is typically some sort of, extension of performance or basically excusing the default termination of the contract. You may need to look to other contract provisions to recover for any additional costs that you incur. And even if you're not able to recover those costs, you may have different angles that aren't contractual. So you may be able to look at if you have insurance coverage available. Some companies have business interruption insurance or other event-specific type insurance coverage that could be helpful in this type of situation. So turning to different types of contracts. So how, again, force majeure provisions, you may see them in many commercial contracts, but there are plenty of contracts where you're not going to see a provision that's titled force majeure. So how, for example, does the construction industry look at force majeure or excusable delay? So, obviously every contract is different. Those of you who are involved in construction may be familiar with the American Institute of Architects, which is otherwise known as the AIA, that creates industry standard legal forms and agreements. And one of those forms, the A201, addresses delays, suspension of work, and terminations, all of which could result from this pandemic or other events that are considered to be beyond the contractor's control. So in the case of the A201 in a construction contract, Section 8.3 states that the time for the contract should be extended a reasonable amount due to the delay caused by whatever unforeseeable event is occurring. Additionally, there's other contract clauses, so you always need to look at your contract in context. You don't want to look at any one provision. You need to look at all of your provisions and see how they're interplaying with each other. So for example, many contracts will have a termination for convenience clause that allows the owner or the prime contractor to terminate the contract really at their will as long as it's not in bad faith. So that would be, for whatever reason. The contractor or the owner may also have the right to suspend performance, or they may even have the right to terminate your contract for default under certain circumstances. So it's important to look at the way that your contract provisions interplay and how the risk has been allocated for events like this that are outside of the control of the contractor. Looking at federal government contracts, again, in most federal government contracts, you're not going to see a force majeure provision. You're much more likely to see what's called an excusable delay clause. And there's a number of different FAR clauses that include excusable delay. You may need to look to your contract's termination clause, which would provide excusable delay as a defense to default termination. But in general, the excusable delay clause in your contract will provide for time extensions for events that cause disruption to your contract due to events that are beyond your control or without your fault or negligence. And again, it's important to note these excusable delay provisions may not provide for any sort of cost recovery. So you might have to go back and look at your changes clause, whether you can submit a request for equitable adjustment. But the changes or the excusable delay clause itself likely is just going to give you some sort of time extension for your performance. So digging a little bit into some of the relevant FAR clauses, FAR 52-249-14, which is titled excusable delay, you can see some kind of overlaps here with the force majeure language, where this clause applies to prevent a default termination if the failure of performance arises from events that are beyond the control of the contractor and also without their fault or negligence. And importantly, this FAR 52-249-14 actually does include explicitly epidemics, quarantine restrictions as examples of those type of events that could be beyond the control and without the fault or negligence of a contractor. So it's important to note that in proving damages under these excusable, or in proving that the excusable delay clause applies in general, you're going to have to show that the cause of your inability to perform is directly linked with the event that's beyond your control. So there can't be other intervening circumstances where, you also are just unable to perform because, your subcontractor isn't coming through with their end of the bargain. It's really, you've got to tie the inability to perform directly to the event. So in this case, to COVID-19. So how have courts in the past looked at the excusable delay clause when it comes to epidemics or quarantine restrictions? Again, there haven't been a lot of recent cases aside from that Civilian Board of Contract Appeals case. But if you kind of look back in time, there's a couple more cases out of the Boards of Contract Appeals that look at when this excusable delay clause can be triggered. And basically what these cases have shown is that demonstrating excusable delay for a contractor is an uphill battle. It's a very high standard, and that's why it's so important that you ensure that you provide notice, really timely notice, and that you keep really good documentation that actually shows the causation of the event as triggering your inability to perform. So one case, the Ace Electrical Associates case, this was a case out of the Armed Services Board of Contract Appeals. And in that case, the contractor claimed that 30 to 40% of their workforce had come down with the flu, I believe it was, from a flu epidemic, and that they'd been absent and they'd faced additional, costs and inability to perform due to the absenteeism of their workforce. And the ASBCA unfortunately rejected the contractor's claim, and they basically found that the contractor simply had not provided sufficient evidence. So they hadn't kept good enough records, and they really just hadn't tied the event, so the flu, to the delay that had been caused well enough for the provision to apply here to provide relief. So again, it's very important to keep good records, to show, for example, if your workforce is out, who is out because of COVID-19, how long are they out for, what are the costs? How are you actually tying your costs to the disruption in your workforce or ability to perform? So again, going back to what you have to show for either force majeure or excusable delay, you also have to show mitigation under excusable delay. So you have to show that you've taken reasonable steps to avoid any sort of foreseeable delay that occurs. So in this case, it may have been wholly unforeseeable, I think, for most people that COVID-19 would essentially shut down the world for such a long period of time. But as we continue, working from home and continue seeing these effects, it may become more foreseeable for contractors, and you need to take steps to attempt to mitigate your damages as much as possible within your means and ability. So again, showing causation, keeping good records, and generally just making sure that you look at your contract and that you understand how this risk is being shifted, whether you're the one who bears the risk, or whether the government or maybe your prime contractor bears the risk in this situation. That's really important. So always look to your contract and be aware that the changes in law and the way that courts are going to be interpreting the CARES Act and other local emergency orders may affect your ability to recover or to claim these type of contract delay and avoidance provisions as well. And with that, I think we're at the question and answer period. And Becky, I will turn it back to you.
All right. Thank you so much, Emily, for that excellent and very thorough discussion of force majeure and excusable delay. So I have, as moderator, I've got a few questions that I'm going to go ahead and answer. If any of the attendees have any questions that they want to ask any of our presenters, please go ahead and type those in, and we'll get to them to the extent that we can, given the time. So I'm going to start off with Barry Horowitz, who presented on the CARES Act, Section 3610. I'm going to start with the question, you referenced that there's an open question about recovering costs for personal protective equipment when employees return to the workplace. Can a contractor be compensated for personal protective equipment when they feel it's necessary to perform a contract?
Thank you, Becky. This is an interesting question. As we discussed with regard to Section 3610, 3610 speaks specifically about cost for paid leave, which doesn't cover that issue. But it's a critical point that a lot of contractors are wrestling with, and both GSA and DoD have issued guidance indicating that such costs can potentially be reimbursable. But as we've heard this morning, it depends on a number of factors relating to the specific contract in question. The GSA in March issued FAQs indicating that in some cases contractors can be reimbursed for PPE, and provides that the contracting officer representative should review the contractor's request, determine whether the request is within scope, and make recommendations regarding that request for reimbursement. Likewise, DoD issued guidance that specifically noted that while that type of relief is not within the scope of 3610 itself, such costs for PPE may nonetheless be allowable in accordance with the applicable cost principles in a particular contract. So I think this really highlights the need to, as you've heard this morning, to check the contract carefully and communicate regularly with the contracting officer, because these are issues that are not insignificant ones that will be tied to any contractor's ability to get back to normal operations.
Thank you. So I have another question for you, which is, if a PPP loan is used for payroll expenses and other allowable costs, and then the borrower does not apply for loan forgiveness, is the government entitled to credit for the loan amount?
That's an interesting question that actually comes up in the context of the Section 3610 prohibition on double dipping that I mentioned in my segment of the presentation. Generally speaking, the DoD and OMB guidance issued to date has indicated that a loan that's not forgiven would not be credited against contract-related costs. DOD issued some specific guidance on the intersection between 3610 and PPP, and that guidance provided that to the extent that PPP assistance is allocable to costs allowed under a contract, the contractor should ensure that the government is given a credit for any amounts that are forgiven. And by implication, then, of course, one might conclude that if it's not forgiven, then it would not be credited. The OMB has issued some similar guidance that focuses on forgiven loans, where a contractor would then be essentially holding that federal assistance, and 3610 provides quite explicitly that double dipping is not permitted. So it's an interesting question, but I think the DOD's guidance is the clearest on this, and they've gone out of their way to indicate that their instruction to provide a credit or reduction in billing applies to loans that are actually forgiven.
Okay, thank you. So are schedule delays covered by Section 3610?
Neither the plain language of the statute nor the implementation guidance from DOD expressly anticipates that schedule delays might be covered. That suggests that they're unlikely to be covered. Any delays of contract performance due to COVID-19 could be potentially handled through a request for equitable adjustment or a contract modification. GSA's guidance actually speaks to that by providing that the government can make changes to the period of performance by using, as they say it in their guidance, appropriate changes clauses that apply to the contract. Again, this is one of the areas where Section 3610 speaks specifically to recovery for labor costs for paid leave, but the guidance that has been issued indicates that there may be other contractual mechanisms that could be used to cover schedule delays.
Thanks. Hey, Emily, because you spoke on excusable delays, do you have anything to add to that answer that Barry just provided?
Yeah, I think that if, assuming your contract has an excusable delay provision, generally the government contracts clauses, so the FAR clauses, specifically include epidemics and quarantine restrictions in their stated definition of what can constitute an excusable delay. So you may also look to those clauses and try to invoke those clauses to get the additional time or to excuse some sort of non-performance so that you can avoid a termination of your contract.
Thank you. I think that's helpful. Another question for Barry is Section 3610 states that its authority applies only to, quote, a site that has been approved by the federal government, including a federally owned or leased facility or site. The statute only mentions government facilities. What about contractor facilities?
That's a great question. It talks about a site that has been approved by the federal government, and the wording, indeed, as you said, only talks about government facilities. This is an area where the guidance has been pretty uniform in providing that contractor-owned or contractor-leased facilities can be covered. The GSA's guidance provides that all contractor and subcontractor work sites are considered to be approved, except for work sites where the contracting officer specifically designates them as not approved. So not only do they allow for contractor facilities to be included within the scope of that relief, but GSA implements a presumption that all of the contractor's facilities are on the table. The DOD's guidance doesn't quite go that far, but provides that Section 3610, it says in the negative, does not prohibit reimbursement of paid leave costs, even for contracts that are performed outside of the United States, or prohibit reimbursement even to foreign contractors. So the guidance has been pretty sweeping, and there's nothing that suggests that the relief would be limited only to government sites.
Well, thank you. That's very helpful. So we've been really focused in this presentation so far on contracts and how it impacts contracts. But as people on this call and our attendees may know, there's also been a push by a lot of entities to make more use of vehicles such as other transaction authorities. Are OTAs covered under Section 3610?
That's a great question. The statute actually provides an authority for contracting officers to modify the terms and conditions of a contract or other agreement. And so that has been interpreted to include not just FAR contracts, but OTAs as well. Only DoD has spoken to that at this point in its implementation guidance. DoD states that while OTAs are not FAR-based actions, they are nonetheless contracts or other agreements within the meaning of Section 3610. And so the DoD says that the same principles that are set out in the DFARS implementation can be utilized in an OTA context. So that's a fortunate area where the statutory drafting specifically covers other agreements.
Thank you very much, Barry. Well, you've been on the hot seat for a long time, so I'm going to start asking some questions of David Edelstein and Allison G-Wax, but certainly if you have anything to add to any of the questions I asked them, please jump in. And the same goes for you, Emily, as well. So David and Allison, and I don't know who wants to answer this one, but I'll just ask it and you guys can decide. For subcontractors on federal projects, does their ability to recover for delay or disruption costs depend on the prime contractor's recovery?
I think the answer there is it depends. And
I was just about
what
to
it's
say
going
that,
to
David.
depend on. Well, would you want to take it then, Allison?
All you.
Okay. What it's going to depend on is the terms of the subcontract. And we, Allison and I, have seen both kinds. There are, it is fairly standard and fairly common in federal government subcontracting for the subcontracts to have a relatively strong pass-through clause. Essentially, any delay or disruption or impacts or any changes caused by any act of the owner, you subcontractor submit your request to the prime contractor. I will pass it up to the government, and you get from me exactly what I get from the government. There are subcontracts that don't have that, and there are subcontracts that have more kind of commercial-looking terms, even in the federal government subcontracting sphere. The other thing that it could depend on is the actual source of the restriction or change that is causing an impact to the subcontractor. We have seen prime contractors that essentially take the memoranda and guidance coming down from the government, just slap a cover letter on it and says, here's what's coming down from the government. Subcontractors, I expect you to follow it. And in that case, it will almost certainly be considered an owner-caused or a government-caused change, and you'd be subject to those pass-throughs if you had that in your subcontract. But I've also seen prime contractors who impose restrictions kind of above and beyond what the government is requiring. And in that case, it would not necessarily be subject to the pass-through and a subcontractor's right to recover from the prime contractor wouldn't be as dependent on the prime's ability to get compensation from the government.
Well, thank you so much for that answer. That really addressed the question. So, from what I've seen, the federal government contracting officers have actually been very great in this crisis. But we also know from other things like storms that the federal government, and we have jobs because they're not always wonderful and accommodating in the case of epidemics or excusable delays. So what happens if the government tells you, too bad for you, you signed a contract, you're going to meet the original deadline? What is the contractor's resource?
I'll take this one. And we've seen this actually addressed in the DoD memo that was issued in late March, if I recall correctly. And so what happens is sometimes the contract needs to be finished on time regardless of the excusability of the delay. And so then you're in a situation where you are entitled to more time, and so the actual substantial completion date or completion date that you're entitled to could be a month or two from when the contracting officer tells you to finish. And so in that situation, what you have is a change, and it's an acceleration claim. And so this happens, and this is something that comes up outside of COVID and outside of really natural disasters. It happens anytime you are entitled to additional time and to a movement of the substantial completion date or contract completion date, and the contracting officer says, well, we really need it sooner. And in that case, you say to the contracting officer, okay, sounds good, that's an acceleration claim, and you can have it sooner, but you have to pay for it. And it's the exact same thing that would happen if there was no delay at all and the contracting officer told you to finish early anyways. You would be entitled to an equitable adjustment to the contract. And so in that case, you need to make sure that you give proper notice within the time limits required by your contract, and same deal for subcontractors. You want to make sure that you give notice within the time limits required by your prime contract, and you keep detailed records regarding the costs incurred as a result of the acceleration. If it's not possible to do that, then that's a different issue. Then you have to address that with your contracting officer, and they can't take any negative action against you. As Emily said, they can't terminate you for default for not meeting an earlier completion deadline when you are entitled to an excusable delay. But the answer is yes, they can do that, but you are entitled to be paid for it, and this is the same in private or government contracts.
Okay, great. So what if a contracting officer gives you a list of safety measures to take that are more strict than CDC or state guidance? Do they have that authority as a contracting officer, and if so, what can the contractors do to claim for that?
I think the answer is yes, they can, and that is absolutely, they can do it, and it's absolutely something we've been seeing, particularly in facilities that where they have a security or reason for being overly cautious or more cautious with respect to COVID-19, and I think that as I think every presenter has said. The two big things that you can do there are give notice and track your additional costs. And it is likely that, as Allison and I have said, that this would be something that is recoverable as a change to your contract. Because there's both the change in law, but then there's even, I think the question is asking, the additional requirements imposed over and above what's even required by laws should absolutely be recoverable. you just, again, need to make sure that you're giving notice so the contracting officers know that you consider it a change, and you need to be tracking your costs so that there's no there's no question about the accuracy of your claimed dollars when it gets to that point.
Okay, thanks. Now I'm going to put Emily on the hot seat here just for a couple questions. So if a contractor's force majeure clause in their contract does not refer to pandemics or epidemics specifically, is there any way it could still apply to unavoidable delays or costs associated with COVID-19?
That's a good question. I think it raises a couple issues. One, again, force majeure provisions and excusable delay provisions often do not provide for cost recovery, so you may need to look to other provisions in your contract, like the changes clause, for that. When it comes to providing additional time to your contract, although it might be, it would be good to have the actual words epidemic or quarantine restrictions in your force majeure or excusable delay clause, not all hope is lost if those words aren't in the clause. These type of provisions are often drafted fairly broadly. And again, the key is that you're going to need to show that the event that's causing the disruption or delay is outside of your reasonable control, and that it was not foreseeable to the parties at the time of contracting. So even if your contract doesn't explicitly state that epidemics or quarantine restrictions are going to fall within that excusable delay or force majeure type defense, you may still be able to invoke the clause to get some type of recovery, whether it's additional time or in conjunction with other contract provisions, additional cost recovery.
Well, thank you so much, and we're going to end it by, you should already have the CPE code, but I think it'd be helpful if whoever is in possession of that code just goes ahead and states it on this presentation now.
Yes, sure, I can do that. Hi, everyone. So for CPE credit, the code is contracting, CONTRACTING, capital C, so it is case sensitive. Be sure to capitalize the first letter, and you'll be reminded of that when you get the form to fill out, which you'll be receiving via email.
Well, I really want to thank all the presenters here, Barry Hurwitz, David Edelston, Allison G. Wax, and Emily Unash for joining the NCMA webinar. And if other individuals on the phone had additional questions, we can contact you afterwards and answer those at that time. Do any of the presenters have any other comments or questions?
No,
well, I'm going to end it now. Thanks, everybody.
Thank you very much.